Hello friends, this is Dr. Sumiti Ahuja and I am Assistant Professor from Faculty of Law, University of Delhi. And in our fourth session, which is titled Consideration, we will be covering the following topics. Definition of consideration under the Indian Contract Act 1872, types of consideration, lawful consideration, exceptions to the requirement of consideration for formation of a valid contract, the doctrines of privity of consideration, the doctrine of privity of contract and the exceptions pertaining to it. Before I start with this fourth session, I would like to highlight that this topic, the definition of the topic of consideration, which is given under section 2 clause D of the Indian Contract Act, is one of the lengthiest definitions in the act, and there are various essential components, because whenever I teach my students in the class, first thing I tell them when we start with the definition of consideration is that we have to dissect the definition, because we have to understand. If you will have a look at the definition, which we will be going through at a later stage of this session, you will understand that there is just one line, one sentence which is falling in 4 lines. So, it is only comma, comma, comma which is distributing that provision. So, we have to understand that provision part by part. So, in order to make it easy for you, I have divided into various parts and we will be taking them up one by one. To start with the general meaning of the term consideration, as you can see on the screen, I have mentioned that it is something in return which as a Latin phrase is recognized as quid pro quo, that is when you are returning favor to someone, right. So, in the first session of this course on law of contracts, I had highlighted that consideration, if we talk in layman language, is like buying someone's promise. So, you are giving something in return to a person who is making a promise to you. So, consideration is a legal term that refers to the benefits that each contracting party gains. This is typically payment in exchange for products or services. You can say goods or services. Now, consideration does not have to be in form of money. It can be anything of value that you receive as part of a contract, such as any equipment, goods or some work. So, through this point I have tried to highlight that whenever we refer to this term consideration and we say that we are buying someone's promise, it need not necessarily be that you are paying someone something, some amount of money, because that other person has promised you something. This money, this consideration can be in form of money, it can be in form of goods or services also. Like in one of the previous sessions I had told you this thing, that say for example, a person comes to you and makes an offer to you that say he is willing to sell his car to you for say 2 lakhs, right. So, he is willing to sell his car to you. So, from his side the consideration would be the car which he will be selling to you, and say for example, you accept his offer, that is you are interested in say purchasing his car and you are ready to pay 2 lakhs to him. So, from your side the consideration is in form of money. So, it can be this way also, that one is providing you goods or services and the other one in return of it is providing you money. So, consideration can be money, it can be in kind also, it can be some goods or services as well. Now, you can see that I have highlighted here, consideration has to be of some value in the eyes of law, that is it has to be real and not illusory. So, promising someone that I will go to the sky, I will get moon, stars for you, that is not real, that is illusory, that is something which is not possible, it is an impossible thing, right, and therefore it does not have any value in the eyes of law, right. Now, adequacy of consideration is not a necessary legal requirement. We will be coming across this part when we would be going through the legal provisions also, but at this juncture I would like to highlight a point, that is, it is not necessary. See, if I have a property which is worth crores, it is not necessary that when I have to sell that property, I need to sell that property in crores only. If I have to leave the country, if I am shifting base, I am in a hurry and I wish to dispose of the property, it is up to me. I may end up selling it in, say, crores of property, I may end up selling it in lakhs, right? So, that is up to me, because as per the Indian Contract Act, consideration need not necessarily be adequate, it can be inadequate also. Now, I have highlighted, before we move on to the definition of consideration as given under the Indian law of contracts, I have highlighted this definition by Pollock, who happens to be a jurist also. So, according to Pollock, consideration is the price for which the promise of other is bought, and promise thus given for value is enforceable. So, in our earlier sessions, we have discussed what is the meaning of the term enforceable. If I say my right has been infringed and legal right is enforceable in court of law, enforceable means I have a remedy for which, legal remedy in existence, and I can go to the court of law and put my claim and claim the remedy. So, it is enforceable, that means remedy exists in the eyes of law. Remember, when we had discussed the basic definitions, interpretation clause, definition clause also as we call it, I had told you when we were distinguishing between the terms void agreement and contract, the point of, very small point of difference between both was that an agreement which is enforceable by law is a contract, and an agreement which is not enforceable by law is a void agreement, right. Now, moving on to the definition of the concept or of the term consideration as is given under the Indian Contract Act 1872. I would like to read this definition for you, and then we will see how we can divide this definition into various parts and understand it. It says, when at the desire of the promisor, the promisee or any other person has done or abstained from doing, does or abstains from doing, or promises to do or abstain from doing. This is point number 3. Something, so such act or abstinence or promise is called a consideration for the promise. Now, you can see for yourself on the screen that I have marked this definition, or I have divided this definition into 3 points, 3 parts which are visible on your screen. First is at the desire of the promisor. That means consideration is always given at the desire of the promisor. That means only when the promisor is also ready. And the next is promisee or any other person. Now, this is a very interesting concept. We will be discussing it in detail at a later stage. What we are trying to say here, that see, till now we have just understood that okay, fine, there is a contract. In a contract we need 2 parties, those 2 parties should be competent, legally competent to enter into such contract. It should be out of free consent, and there should be lawful consideration. So, our focus has always been on these 2 parties only, of whom we are referring to. One makes the offer, other gives the acceptance to that offer, right. But if you see this definition here, you will see it is saying that at the desire of the promisor, promisee or any other person can also provide consideration. That means a person who is a stranger, who is not party to that contract, can also provide consideration in a contract. We will be discussing it in detail, but for right now, for the time being, just understand this thing, that if 2 parties are entering into a contract, a third person can provide for consideration on behalf of either of the parties. That is acceptable under Indian law, and that is what is given under the definition also. Now, the third point which you can see on your screens, which I have highlighted, is that has done or abstained from doing, does or abstain from doing, or promises to do or abstain from doing. This does or this doing something or abstaining to do something is something which we have already discussed. I had told you, when I say that promises to do something, that means you are promising that you will be doing a positive act, you will be doing something, doing an act for someone. And when we say abstinence, that means you are promising that you would not act in a particular manner, omission, right? So, we also call it as a negative act. Now, when we talk about these three, this third point here, and you can see it says the tenses are changing. It says has done or abstained from doing, does or abstains from doing, or promises to do or to abstain from doing something. So, these changing tenses are highlighting the different types of consideration. When we say has done or abstained from doing, that means is already done. So, this is what we call as past consideration, right? And then you can see it says does or abstains from doing. We are referring to present tense here, right? So, that is present consideration. Third is promises to do or to abstain from doing something. Now, promises to do, that means you are promising that you will be acting in a particular manner in future. That is why it is the third type of consideration which we were referring to. So, that is future consideration, right? I have tried to elaborate these three concepts, these three types of consideration. We will discuss them along with examples also. So, past consideration, as I said, it has already been done, it has already happened. So, it says a promise or conduct which is made or carried out prior to the formation of a contract. So, you had, say for example, you ask someone, say your bike goes, the petrol gets finished in your bike, right, and you are not having money also. This is a very common example which we generally give. So, money is not there, but you go to the petrol pump and request that person that, see, please fill petrol in this. Maybe that person is known to you or ends up trusting you. So, you tell that person that, see, I am not carrying any money right now, but please fill petrol in my bike and I will be, and please fill petrol in my bike, right, and I will pay you in the next visit, right, or I will pay you at a later stage, whatever. Now, then later on you go specifically and you make that payment to that person for filling petrol in your bike. Now, you are giving that money to that person at a later stage, for which the consideration has already been provided by him to you. That is, he had, at your desire, at your request, he had filled petrol in your bike, but you acted at a later stage and you paid to him later on, right. So, past, already done. Then present consideration, as I had said, if the promise and consideration take place simultaneously, then it is present, or what we also call as executed consideration. It is the most simplest form of consideration to understand. So, present consideration is, you just go to a normal local grocery shop and you just tell that person that find my toothpaste, I just want to buy this one pack of Colgate toothpaste, right. The person gives that toothpaste to you and he tells you the amount and you pay that person there and then. So, this is a simultaneous act. You asking for, you making the offer, the other person accepting the offer, the other person giving you the thing which you had asked for, and you making the payment there and then. So, these things, promise, the consideration, they are going on simultaneously. Now comes the third type of consideration which we call as future consideration. Now, say for example, let us talk about this say a lease agreement, right. So, the contract has been entered into between the two parties, the one who is giving his property on lease and the other person who is taking that property on lease. And now, the terms of the contract have already been written, they are already there in written, and yes, it is agreed between the two parties that the tenant would be taking that property from you from say the starting of next month, say like after 20 days, right? And the day he takes the possession, that is after 20 days, that is the time when before taking the possession he will be giving you the advance rent, the security deposit, etc., etc. So what I am trying to highlight is that you are entering into that contract at a stage right now, and wherein the parties are promising to each other to act in future. That is, I promise that I'll be giving my property to you for rent at after a period of say 20 days, and the other one is promising to you that he'll take the possession of the property, and before he takes the possession will be paying you the rent, the advance rent for say 2-3 months and the security deposit. So these are the two promises which they are making to each other, the reciprocal promises, promise in return of promise, which they are saying that they will be fulfilling at a future period, right. So that's a future consideration, where I am promising that I will be acting in a particular manner at a future time. Now comes the concept of privity of consideration. Remember, when I just referred to this definition of consideration under section 2D of the Indian Contract Act, it stated, when at the desire of the promisor, the promisee or any other person, right. So the concept of privity means that if the thing is between two people, no third person can intervene. So the two parties are privy to it. There is no involvement of third person. But our law says that at the desire of the promisor, promisee or any other person can provide for consideration. So do we follow privity of consideration in India? No, we do not. Because, and this is something which is written in our law only, that we do not follow privity of consideration, and consideration can be provided by any third person also, who is a stranger to the contract. Now, but yes, before I give you the facts of this case law, which I have mentioned on in the slide briefly, just let me tell you a point of distinction between the Indian law and the English law here. I just mentioned that in India we do not follow the doctrine of privity of consideration, right. That means third person can also, stranger to contract can also provide consideration. But in English law, privity of consideration is there, or if I may say, doctrine of privity of consideration is followed in English law. That means only the two parties who are entering into contract can provide for consideration, no third person can intervene, right. Now coming briefly to the facts of this case, Venkat Chinnaya Rao versus Venkat Ramaya Garu, which is popularly known as I am writing on the screen, Chinnaya versus Ramaya. That is also a way of writing this case, because you will see this reference in many textbooks or many sources that it says Chinnaya versus Ramaya, but it is the same case law, right. Now what happened in Chinnaya versus Ramaya, if I may explain to you briefly. So there was this lady who owned certain properties, and she annually used to give some amount of money to her sibling, and she used to do that every year, annual payment, right, annuity. Now she entered into a contract with her daughter, right, wherein the lady, that is the owner of the property, the old lady, she made a promise to her daughter that she will be transferring the title over that properties to her daughter. Now provided that the daughter of hers was to fulfill had to make one promise from her side also in return. So that promise was that she agrees that once she gets the title over that property, those properties become hers, she will continue to make that payment, to give that annuity to the sibling of her mother, like her mother used to do earlier. Fine. So the daughter agreed to it. They entered into a contract, and the daughter clearly promised or agreed that she will be paying this annuity amount, right. In fact, she gave it in written to the sibling of her mother that I agree that I agree to pay this much amount of money on annual basis, right. Now, she committed a default. Once she got the title over that property, once that contract came into picture, she defaulted in making that annual payment, right. Now, the question arises, and the sibling, say for example, the sibling here of the mother sues the daughter, right, sues the daughter. Now, she says that how can you sue me, because there was no contract between you and me, the contract was between my mother and me. My mother promised that she will be transferring the property in my name if I agree that I will make that payment to you, but I defaulted in that payment. So, if there is someone who has some locus or who can approach the court to claim relief in this case is the mother, because if I did not fulfill the condition, there was a breach of contract, but contract was with mother, not with you. So, you cannot, right, because it was a one-sided promise. There is this concept, or if I may say, there is this term nudum pactum. Nudum pactum means a bare promise, that is, it is one-sided promise. You are making a promise to someone, but the other party is not making any promise in return. So, you are promising that you will do something or you will act in a particular manner, but in return of your promise, the other party is not promising anything. So, it is a bare promise, it does not become a contract, right. Now, so yes, continuing with Chinnaya versus Ramaya's case, I just told you that the daughter stated that I did not enter into any contract with you, how can you sue me? I am not under any obligation to pay that amount to you, right, and I have not committed any anything wrong. Now, the question arose, is it whether it was correct, whether that sibling of her mother was in a position to sue this the daughter here. So, consideration for the promise can be provided by other party also, can be provided by the third person also. So, the daughter gave it in written or made a promise to the sibling that she will be making that payment. From the side of the sibling, the consideration was provided by the mother, that is, she provided the property, she transferred the property in the daughter's name. So, it was held that in India, the privity of consideration doctrine is not followed, and even a third person can provide for consideration, which means that the contract between the mother, the daughter and the siblings of the mother was very well valid contract, wherein from the side of the mother's sibling, mother had provided the consideration. Now, coming to this concept of privity of contract. So, now we understood what privity is, that is, no third person or no stranger can intervene, right. Now, so if we say that privity of consideration means that the third party cannot provide for consideration, what do we mean by privity of contract? Privity of contract means no third party to that contract, that is, no outsider, no stranger to the contract can sue if breach of contract is committed by either of the party, right. So, no stranger can provide for consideration is what we mean by privity of consideration, and when we say privity of contract, we mean that no stranger can sue if the contract has been breached, right. So, that is what privity of contract is. Now, regarding the doctrine of privity of consideration, we just realized that privity of consideration is not followed in India, and that is clearly reflecting from the definition under section 2D, 2 clause D. But do we have doctrine of privity of contract in existence in India? The answer is yes. But at the same time, we need to understand that there are too many exceptions in existence to this doctrine. In fact, if you will do your internet surfing, you will try to read about articles in the area of privity of contract, scholarly articles, not blogs, I am saying generally, even scholarly articles, you will also see that people have reached to this conclusion that this doctrine of privity of contract has been diluted so much because of these because of too many exceptions, that it seems it is better to do away with this doctrine, right. That was only to add to your knowledge. Now let us see what is there on the screen. It says, stranger to a contract cannot sue when breach of contract takes place. This is what privity of contract is. We follow the doctrine of breach of contract in Indian law, but with exceptions, which allows a third party to sue in certain circumstances. That is, when any of those exceptions is in existence, or the situation related to any of those exceptions is in existence, then at that time, or then during those times, even a third person can sue in case of breach of contract. Now the various exceptions which you will see, you will find in many textbooks and many articles are trust, family settlement. Here trust, we do not mean trust means a fiduciary relationship, trusting someone. Here we are talking about the relationship of a trustee and beneficiary, right. So trust, then it comes, then the second is family settlement, then it is assignment of a contract, then it is acknowledgement or estoppel, covenant running with the land, right. So these are few exceptions. Now trust, as I said, means the relationship of a trustee and a beneficiary. So trustee is trustee, say for example, is someone who is holding a particular property on behalf of the beneficiary, say for example, because beneficiary is a minor, and minor does not have those rights. He cannot enter into a valid contract with anybody in relation to that property, right. So a trustee is appointed, and the trustee takes care of that property till the time the beneficiary comes of age and is able to take the title over the property and discharge that title also in the manner in which he or she likes, right. Now family settlement is also something that it is an exception. If two members of a family have reached into a contract, have made certain agreement, have entered into a contract, but that contract is in relation to or involves, or it is dealing with a third person, third member of that family, then that third member of the family has a right to sue in case of breach. Then assignment of a contract, that is assigning of rights under a contract, acknowledgement, estoppel, right. Covenant running with the land, all these are also exceptions. But here at this stage I would like to tell you about this judgment of Nawab Khwaja Muhammad Khan versus Nawab Hussaini Begum. You will see that in most of the cases wherein we say this is a case related to, or this is a situation related to exception to privity of contract, you will find that mostly the situations or the incidents are dealing with a beneficiary whose rights have been affected, whose interest has been affected, and who is allowed to sue in case of breach of contract, right. Mostly you will find cases related to trustee or trustee beneficiary, right. So third party benefiting out of that contract, or you can say in whose favor that contract was entered into. Now in Nawab Khwaja Muhammad Khan's judgment also, the husband, and so this case basically has say if I may say four characters. Contract was entered into between the father and father-in-law of this lady here, Nawab Hussaini Begum. Now and at that time when this contract was entered into, this lady Hussaini Begum and her would-be husband, they were minors. So on their behalf, their respective fathers had entered into a contract, and in that contract the father-in-law of this girl had promised, he had made a promise that after the marriage, of you can say from the date of the marriage, he promised to pay some amount of money to his daughter-in-law as betel leaf expenses. Betel leaf expenses. Now, betel leaf expenses here, we do not mean any kind of leaf. We are trying to say this is a concept known as kharch-e-pandan, which means that this amount would be given to this lady, and she can utilize that money in any manner she wants to, right? It was her money. Now, so under that contract, the father-in-law had made that promise that if this marriage will take place, then he promises that if this lady marries her son, if this girl, not lady, she was a minor at that time, if this girl marries his son, he would be paying her a particular amount of money as betel leaf expenses since or from the date of marriage onwards, right? Now, they were minors. When they were slightly grown up, that is when she started living with her husband. She lived with her husband for some time, and then she again came back to her own home. The father-in-law stopped giving that particular amount of money or the betel leaf expenses to the daughter-in-law, and basically he refused. He said that she had left the household and she is not having any right over this money anymore, right? Now, this daughter-in-law, aggrieved by this action, by this act of her father-in-law, she approached the court. Now, herein, see, the contract was made between the father of the girl and father-in-law of the girl, but it was who was benefiting out of it, in the sense the monetary benefit here was being given to the daughter-in-law. Now, here the daughter-in-law, who was the beneficiary, she is filing a suit against the father-in-law, that is, whatever arrears are there, whatever money he had promised, he should give that, right? Because he had stated that, see, I was under obligation to make that payment till the time you were in our household, in your matrimonial household, you were entitled to that money. Now you have decided to stay away from my husband, son, and you have deserted your husband, so you do not have any claim over this money. But the court stated, and in fact, you do not have the right to sue, because I did not enter into any contract with you. Court held that she, being the beneficiary of that contract which was entered between the two fathers, she being the beneficiary, if the father-in-law or if one of the parties committed a default, she had the right to sue the defaulting party and get her claim, get her remedy, right? So that is what the court held. In fact, in this case, there were certain situations, but finally the court held this thing, that she had the right to claim that particular amount.